Good morning, and welcome to today's webinar. Today's topic is Ask a Pro, Collections, Compliance, and Your Credit Union. My name is Dawn Pagan, and I will be the moderator for today. I've been the primary contact for hundreds of Weltman's credit union clients in Ohio and throughout the U.S. for more than 20 years. I work closely with boards of directors, CEOs, and collections staff to help evaluate their current recovery strategies, and I work with them to find effective solutions to meet their business objectives. Before we get started, I would like to take a moment to go over a few housekeeping items. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking on the question button in the control panel and typing your question. Your questions are only visible to me, and they will be addressed throughout the presentation where applicable. A little bit about Matt before we start today. Matt is the leader of Weltman's Credit Union Group, and he represents exclusively credit union clients on a broad spectrum of legal and regulatory issues. Acting as general counsel, he advises on labor and employment, trust and estate, and litigation-related issues. He also performs regular transactional work, including contract review and negotiation, and counsels on commercial paper and check issues and other collection matters. Without further ado, let's get to the first question. Okay, Matt, the first question is, what are the differences between a direct and indirect loan when it comes to repossessing collateral on a defaulted loan?
Good morning, everybody, and thank you all for attending today's Ask a Pro session. Just as a point of clarification up front, many of today's questions are governed by state-specific law. Most of today's attendees are Ohio credit unions, and my responses are Ohio specific, but I'm also mindful of other states' credit unions on the call today, and we'll be addressing those points too. In general, most of the laws pretty much follow the same based on the topics that we're discussing today. Where they deviate, I will let you know. For example, this first question does tend to be an Ohio specific law. Repossessing collateral on indirect loans, and just to take a pause for a minute because this is a common misconception, an indirect loan is typically a retail installment sales agreement loan. There's an assignment provision in it. The dealer takes out the loan with your member and thereafter shops it typically, and then the credit union would take the loan by way of assignment, and that triggers additional laws. But that's a key thing because many credit unions refer to indirect loans as ones that are taken out at the dealership but using credit union paper. Those are direct loans, to be clear. So when we're talking about indirect loans, we are talking about assigned loans, typically retail installment sales agreements, and those are governed by the Ohio's Retail Installment Sales Act. In cases where a credit union is repossessing collateral in Ohio, it must adhere to these additional requirements, which include, most notably, a right to cure, which gives the members 20 days to cure the deficiency, or if the credit union is late in sending the notice out, 15 days after the secured party of the credit union sends the notice, whichever is later. And it requires several things in that right to cure. You can require as payment all installments due or past due at the time and any unpaid delinquent or deferral charges. You can also request $25 of the repo fee, the repossession cost, the balance of which cannot be included in the demand as part of the right to cure. It has to be added to the time balance of the loan. And I want to emphasize that because that is a common problem. Oftentimes credit unions, let's say the fee is $450, $500, they'll include that in its entirety in the right to cure, which they cannot do. And so be very careful with that. So in addition to that, you can also request cash surety payment equal to 2 installment payments. And that's it. And so be very careful with that. The other thing is that they only get that right one time. If they default a second time, they do not get that right to cure a second time. Other deviations are that the collateral must be sold at a public sale. You cannot sell indirect loan collateral at a private sale. So that's a substantial deviation, and the credit union must set a minimum price, which can be somewhat difficult only because if the vehicle does not go for that minimum price, you have to reset the sale and send a new notice, because that minimum price has to be on the notice of sale. And that notice also must go out via certified mail. So those are the key differences for an indirect loan. But for the rest of you on the phone that are not Ohio, or for those of you who do not do indirect loans, there's still something that I want to reiterate, which is that the Uniform Commercial Code has certain requirements that are in addition to the ones I just mentioned. And this is, the UCC is something that's been adopted by all states. And so there's certain requirements everyone must adhere to, such as when you set a sale date, you must send a notice of sale at least 10 days prior to the sale occurring. And thereafter, once the sale occurs, you must also send a notice of deficiency, and that notice of deficiency must go out before you make a demand for the deficiency. And each of these notices are statutorily required and have very statutorily specific elements that go into it. They cannot be altered, they cannot be deleted, they cannot be edited or moved around. I mean, the order is important. And I emphasize this because class action attorneys love to pick apart these notices, and making mistakes on them or editing them, things like that, give rise to potential class action claims. They can assert essentially a $500 statutory damage provision per violation. And if you talk about the, particularly if you're a larger credit union, you can imagine very quickly if they find even one shortcoming in your letter, for example, omitting the day of, the notice says you have to list the sale date and day. Maybe they omitted the day. Is that sufficient? It could be to justify a $500 penalty per time you did it. And you roll that out over time, plus attorney's fees, very quickly the numbers can add up.
Okay, Matt, we do have a question. What's your opinion about selling vehicles on the credit union property? Repoed vehicles.
My opinion is not high. I would dissuade one from doing that. Invariably, there's another number of things that come into play. If you do it, you better be setting a sealed bid notice. You have to advertise. You have to make sure you're holding the collateral out to the public for sale. And so you're going to get more scrutiny in those cases.
Okay, I think we're ready for the second question. When should we accept a power of attorney, and what elements should we be looking for when we accept a power of attorney?
Okay, and again, I'll remind everyone of my earlier caveat, which is this is based on state law, but most states have adopted certain aspects, if not all, of the Uniform Power of Attorney Act. One difference in Ohio is that Ohio did not adopt the provision that requires financial institutions to accept a power of attorney. And this is a very significant point. So for Ohio credit unions on the line, and for those that aren't, you want to verify this, but the baseline is when you have a member that's coming in and you're not comfortable accepting a power of attorney for whatever reason, keep in mind, unless it's a military power of attorney, which I see very few of, quite frankly, you do not have to accept it. So that is your baseline. Anything you accept, you're doing so as a member courtesy. And so that I like to always point out up front, because sometimes, invariably, when somebody's particularly doing something wrong, something they shouldn't be doing, they're going to get aggressive. And they're going to try and force it down your throat. And in those cases, typically the credit union calls me and we kind of go over it and then don't accept it. But just know that that's kind of the power you have in these cases. So you should feel a little more empowered when you're looking at them. But when you do decide you're going to accept it, you want to look at the document, make sure it's legitimate. So as a general matter, the first thing I look at, is it drafted by an attorney? If it's drafted by an attorney, automatically I'm going to be more comfortable with it because we can verify its legitimacy through that attorney. If it's drafted by an individual and the individual is not presenting it, then that could be an issue. We'll want to verify with the individual if the power of attorney is valid, that it comports with their wishes, that it hasn't been revoked or modified in any way. We want that verification step. If you can't get a hold of the member because they're, let's say, incapacitated in a nursing home, for example, then that's when we look at the attorney who drafted it, give them a call, and verify to the best of their knowledge it's still in force and effect. So that is the kind of thing you definitely want to be looking at on the front end. The other big thing is states vary. Some states allow a power of attorney to be witnessed in duplicate to be valid. I do not think that's a sufficient basis upon which to accept a power of attorney. Notarization is what I would require. That power of attorney better be notarized. Like I said up front, these are tools to commit fraud. If you just have any old Joe Schmo witness, how do you really know it was properly executed? So witnesses just in and of themselves are not sufficient. Powers of attorney should be notarized. Other things you want to look at in that is it currently in effect? So for example, some powers of attorney have language that provide for them to be what's called a springing power of attorney. That is, it springs into effect at some given event. That event is incapacity. So if an individual is incapacitated, the power of attorney would then take an effect. So you want to check to make sure that language isn't there or is, and take appropriate steps. So if it's in effect, then we need to look at what requirements, under what circumstances we can accept the power of attorney, such as getting a physician statement or court paperwork, something, and adhere to that before accepting the power of attorney. Another component which has been subject to change based on changes in Ohio law, I think going back maybe to 2012, is durable powers of attorney. Historically, a durable power of attorney had to say it was durable in order to be durable. And durable means that it survives incapacity. So it takes effect, it's good, and after the principal becomes mentally incapacitated, let's say, it's still in force and effect with that durability language. In Ohio, what they've done is they've kind of stepped back and said it doesn't have to say durable in order, it's going to be presumed to be durable unless it specifically states that it's not durable. So I prefer nonetheless, and as an attorney, I mean, if I were drafting these powers of attorney, I would still put durable in there just for clarity, but it's not necessarily required. Something to keep in mind, of course, is that, and I hope most of you know this, powers of attorney cease to take effect at death. Now, obviously, you may be in a situation where the member passes away, you're unaware of it, and the power of attorney wrongfully takes steps to take money out, whatever the case might be, and that's ultimately not on you so long as you didn't have knowledge of the death. But once you're aware that that member died, nobody at the credit union should be accepting that power of attorney for any reason whatsoever. Okay. The other thing I would point out on powers of attorney are, consider these, going back to what I said at the outset, it's optional for your acceptance. I would only allow these for routine transactions. If the member, for whatever reason, cannot get to the credit union to make withdrawals, deposits, things like that. Never should you, in fact, you can't, unless the POA specifically states, change beneficiaries, add account holders, nothing. I wouldn't allow it even if it does state it. It's too self-serving and can be problematic. So I would not allow it for that. I would not allow it for members to take out loans, take out mortgages. These are problems. One thing that we've seen is that if you have a member who's elderly and the family realizes there's a house, they want to maybe take out a mortgage because they cannot do a quit claim. because the member's going to go into a nursing home. Medicaid has a lien on that house, and they will look back 4 or 5 years to see if what's considered a fraudulent conveyance. And in those cases, that quit claim can be undone by court order. So what we've seen is members actually come in, or their children, their heirs, and try to use a power of attorney to get a home equity line of credit and draw as much equity as they can out of that house. Well, what's going to happen at the end of the day is you're going to be the new owner of that home. And so those are collateral things that you also want to try and avoid. So again, routine transactions only when considering powers of attorney.
Okay, Matt, we do have a question about the first topic. The question is, please reiterate what is true indirect loan versus just dealer financing directly through our credit union.
Okay, sure. So a direct loan in the most common sense is, that we all know, is the member comes to the credit union, they take out a loan, the parties at issue are the credit union and the member. A true indirect loan, on the other side, is one where the credit union member goes to ABC dealership, they take out paperwork, and it should typically state a retail installment sales agreement. They sign the agreement with the member. The credit union's name's not on it at this point, okay? Thereafter, and I think what typically happens is the dealer then they know based on some things they're going to be able to get somebody to take the loan, whether it's you or Huntington Bank or whatever. And they will then assign their rights to that loan to the financial institution that's taking the loan. That is the true indirect loan. The hybrid in between, I think, which is what the question is if you have a member who is going to the dealership, they're taking out a loan, they're using the credit union's paperwork, or the credit union's name's written on it, and it's just the credit union and the member on the note, it is a direct loan. For reasons that I cannot understand, maybe people just like to see their name on things. I've seen dealers put their name on it. Why? They're not a party to the note. Please don't allow them to do that, because what that can potentially do is trigger an argument that it is in fact an indirect loan. Now, I'd have to ask for some opinion here about that, and I think you might get some deviating opinion, but it's not a good practice, and it adds nothing. So where you have a dealer arrangement, instruct those dealers not to put their name on where there's no reason for it. They're not a party to the loan.
Okay, Matt, we have a question about power of attorney. What happens when a power of attorney has been revoked? How would you know that it has been revoked?
You'd have to be informed. And that's the risk. If you're a person that's generating a power of attorney, you're extending certain risk. You're imposing liability on yourself. I mean, that's the case. So if you're issuing a power of attorney, you better know where that's being used and trust the person that's using it. So when you go to revoke it, it's your responsibility to go notify all those people that have it. So when it's revoked, you have to notify everybody that's in receipt that it's been revoked. At that point, you're responsible for revoking it. Now, just as a side note, a lot of times, family feuds involving money, things like that, where this gets it into a situation where it's going to be a back and forth. We're revoking this one, we're putting this one in place, we're removing this, we're done. Party's over. We're not accepting power of attorney, period. And so that's what I kind of go back to my initial statement is, when in doubt, when you're not comfortable, when things are turning ugly, we just hit the stop button, and we're not going to accept powers of attorney at that point from that particular member.
Okay, Matt, back to indirect again. Is a right to cure required on a direct loan? Can you send notices with a certificate of mailing versus certified mail?
A right to cure is not required on a direct loan, and those notices of sale can go out regular mail, although I don't necessarily recommend it, because you have to show that it was sent. You do not have to prove that it was received.
All right, I think we're ready to move on to the third topic. Should we set up trust accounts? If so, what documents do we need in order to do so?
Okay, so this is a good one, and for those of you on the call today, on our webinar today, that set up trust accounts, and you haven't already heard my spiel on this, sit up in your chair and start taking notes, because this is good stuff, and you're going to be happy with what I have to say on this. First, just as a preliminary matter, the credit union must confirm that through its bylaws or code of regulation that the credit union is actually allowed to set up trust accounts. Most do, but that's simply a housekeeping measure that I always caution credit unions to check, because I have seen instances where that language is missing. After you get past that, setting up trust accounts can involve very complicated trust paperwork, and can be 40, 50-page documents. It can have different amendments to it, a number of amendments, and it becomes very complicated. And your eyes glaze over when you read them. As a non-attorney, I know that's the case, because even as an attorney, when I get these documents, 45, 50 pages of legalese, it's hard to stay awake, truthfully. So where the member comes in and wants to set up a trust, and you can do it, require them to provide you what's called a certification of trust. And this is an animal set out from the Uniform Trust Code, which Ohio has adopted and most states have. And basically, it provides a simplified trust document, the Cliff's Notes version, if you will, a summary of the trust. And if they can present that, you don't need the entire trust. So this is great news for us. Now, the important thing to keep in mind with the certification of trust is it requires 8 elements. 8 elements. And I repeat this because it's only 8 elements. And I give credit unions the actual statute when they have attorneys coming in, because attorneys regularly miss the elements. And it confounds me, because even when I give them the actual law written in statutory form, they miss it. And I'll explain why it's important to have each and every element in a minute. But those elements include a statement that the trust exists and the date the trust instrument was executed, the identity of the grantor, the identity and address of the currently acting trustees. And let me repeat the word address, because for some reason, like 70% of the certifications I get are missing the address. It's right on the statute. So that has to be in there. The powers of the trustee, and that can be listed in the certification. I also would suggest getting an excerpt of the trust that supports what those powers are, whether the trust is revocable or irrevocable. And if it's irrevocable, it will be in the title, first of all, so that will be clear. But if it's revocable, if it says it's a living trust, for example, that's a revocable trust, the identity of the person holding the power to revoke the trust, and that's typically going to be the grantor. But again, that language has to be in there. The authority of co-trustees to sign or otherwise authenticate, and whether all or less than all are required to do so in order to exercise the powers of the trustee. The certification also must state that the trust has not been revoked, modified, or amended in any manner that would cause the representations contained in the certification of trust to be incorrect. And literally, that can just line for line be in there like that. It must be signed by one of the trustees as well. And the reason all 8 of these elements is important is because this section provides that the credit union is given a safe harbor. They won't be liable for accepting that trust certificate if there's provisions in it that deviate or are incorrect from the original trust. So that's a gift that we want to rely upon. If you have questions about this is one of the things I get asked about most. Feel free to reach out to me. I'm happy to go over these points with you. It will simplify your trust account administration. It will make it much, much easier.
All right, Matt, what should a credit union do when funds are accidentally deposited into the wrong member's account and the member spends the money? Is the member liable for paying back these funds?
So I think hopefully most of you already know what the answer to this question is, but funds can and regularly do get deposited into the wrong account. I'm sure it's happened to every credit union that's on the phone multiple times. And, it can be the member's error, it could be the credit union's error, it doesn't really matter. But particularly in cases where it's the credit union's error, once we become aware of that, we want to reverse the transaction, take the funds out as quickly as possible to the extent they're still there. Because otherwise, once the member comes along and finds them, of course, they're going to spend it. They're going to go on a shopping spree, of course. It's what happens all the time. Hopefully not all the time. I think there's some credible and honest people out there that wouldn't do that, but so many do. All too often, members mistakenly believe that they can spend this money with impunity because it's the credit union's fault. It wasn't their fault, and therefore they're not responsible for paying it. Wrong. They are responsible for paying it. It's called unjust enrichment. In other words, there is no free lunch in life. So, yes, they do have to pay it. And if they don't, you can contact me. I'll send them a nasty gram reminding them of their legal responsibilities. And if they still don't want to pay and the amount's enough, we can sue them in court. And, the judge can explain to them the shortcoming in their rationale. So we can hopefully recoup it that way.
All right, Matt, I have a question. What is the statute for the trust information?
Statute for the trust information. They're going to call. Okay. So, give me 1 second. I don't think I have the. Give me 1 second. I will get it right up. It is Ohio Revised Code Section 5810.13, and what you're looking at is Section A, 1 through 6, B, and C. And it's not necessarily in that order. As statutes are written, they're always a little bit cumbersome. The authentication, the signing provision, it should obviously be at the end, but it's literally like, I think, something like A, 1 through 6, C, and then B. And the order isn't important. Unlike the notices of sale, and if it's called a memorandum of trust or something else, the title isn't important. It's the elements, and they all have to be in there exactly as it is. And what I say to folks is, when a member comes in, because they want to be competitive, likely they paid an attorney and they're annoyed you're telling them something their attorney didn't. You can print that up and give it to them. It's hard to argue with the statute, so you'll have it right there. What you do not want to do under any circumstances, though, is generate an approved certification, because we're not giving members legal advice. You can give them what the law is. They can take that and do what they want, but I've had credit unions approach me saying, can't we just simplify this by generating our own quote-unquote legally compliant certification of trust and accept it? The answer is no. That has to come from the member.
Okay. Next question. The credit union's collateral is sitting at a repair shop or storage facility. Is the credit union responsible to pay storage fees or fees to repair the vehicle? Also, what rights does the party in possession have to the vehicle?
Okay. And again, the answer to this question does vary in some part by state, but I think Ohio's law is probably the prominent law here. I think it's in the majority, and that is notated title liens are a priority over a possessory lien, a possessory lien being a garageman's lien, a mechanic's lien, that sort of thing. So we have priority rights to the collateral because, quite frankly, our lien interest was already noted and made available to the public, to the world to see, up before any of these other rights came about. So that is generally the prominent law, is titled lien interest prevail. The credit union's lien interest prevails. There are some exceptions to this. So in cases where the standard scenario, in cases where you have a vehicle, a storage facility, and lo and behold, it's got $10,000 in storage or whatever the number is, and they say, you need to pay us or we're not giving you the collateral back, you might remind them nicely that, Ohio's law is that we have priority, and if they sit on their hands, that's when, maybe we'll give them a call and have us give them a friendly reminder that they need to turn over the collateral. If they still don't want to cooperate, we can sue them. We can seek compensatory damages because they're wrongfully withholding your collateral, and that's called conversion, and that comes with nasty damages, 3 times the value of the collateral, plus attorney's fees, plus an order to get the collateral back. Now, is a judge going to award all that? Maybe not, but it definitely will get those people's attention and turn that car over much more quickly. So that is a certain recourse that you have. Now, they can raise defenses. So let's say this facility is in possession, but they put it's a repair shop, and the vehicle was brought in because the engine fried, and they had to put a new engine in it. Well, now you're going to get this vehicle, take it to auction and sell it, and something tells me you're going to get a little more money than you would have with a brand new engine in it versus a car that wasn't running. And courts are courts of equity, so they are going to look at that and say, yeah, credit union, you have to kind of look out for the folks that contributed there too. So they are going to there's going to be some practical negotiation, goodwill that we're going to want to engage in with them as part of the process to make sure they get paid and we get paid. I mean, obviously, that can be a creative resolution, however the settlement comes about. But that's something to keep in mind. It isn't going to be an all or nothing. I'm always going to get the collateral and I'm always going to get to sell it, and they can take what, if anything's left. That's not, always going to be the case. So just keep that in mind. The other instance you want to be mindful of is in a case where you have a law enforcement tow. Where that happens, this is, keep this in mind, it's a public policy concept. So the tow facility is doing the public good by honoring the law enforcement's request to pick up the collateral and store it. In those cases, at least in Ohio, and I suspect other states are the same or similar, the law enforcement agency is the one that's responsible for notifying the credit union, not the storage facility. Meaning, if you have a complaint about the fact that you weren't notified, then you need to take that complaint up with law enforcement. And of course, they have sovereign immunity, and so you really don't have any legal recourse against them. So unfortunately, in those cases, you may be stuck paying the fees.
Matt, what if the vehicle appears to be totaled and the borrower will not respond to the insurance company to assert the claim of loss? What can we do?
Okay, so this is unique because, and it's an unfortunate thing too, because the credit union in these cases is what's called a third-party beneficiary under an insurance policy. So we can take steps to try and enforce our rights. They could be expensive, but one of the problems you have is you have to assess the risk here. The contract in these cases is one between the member and the insurance company. Again, we're merely a third-party beneficiary. If there is a dispute with the member and the insurance company about value and we get involved, the member could have a claim against us for something which is called tortious interference of contract, meaning you are merely a third-party beneficiary credit union. You interfered with my contractual right to negotiate a fair and payout and seek whatever damages they're going to try and seek. I think a more practical approach is to remind the member that they're on the hook for the whole amount, and if they don't pay you, you're going to sue them and they're going to have to pay the entire amount. You're not going to have to take the collateral or anything. You can get a lien on their house, you can garnish their wages, etc. And so people, I think, don't realize, they kind of go around the world not realizing some of this, that these are the consequences that can happen. But in those cases, you can otherwise risk trying to go with the insurance company and go around the member, but I don't necessarily recommend it because of the risks that I mentioned. So, being practical and helping the credit union member understand what their legal responsibilities are may be a more effective approach. Because I think a lot of people think, oh, well, the collateral's damaged, it's totaled, I can't drive it, I don't have to pay for it anymore, and what is really simplistic thinking. But, that's my thoughts on it.
Okay, regarding artisan liens, what is the maximum that they are allowed to charge for storage? Is there a code that limits the days and amount they can charge?
In Ohio, there is an amount, and I don't have offhand that amount. Amy Holbrook of our office, I'm certain, has that committed to memory. So if you want to reach out to Amy, her email address is aholbrook, HOLBROOK, @weltman.com, and she can generate that dollar amount off the top of her head.
So what happens when a payable on death beneficiary dies? Do the funds get paid to the POD beneficiary's estate, or should they be paid to the original account holder's estate?
Okay. So to clarify this question, this is kind of the exception question. In a standard scenario, the account holder dies, the payable on death beneficiary is still alive, or beneficiaries are still alive, and we pay them out in accordance to the terms of the POD. Simple enough. It's in cases where the payable on death beneficiary dies first, and then the account holder dies, what to do? Well, if there's one POD beneficiary, it's simple enough. The money gets paid to not the estate of the POD beneficiary. It gets paid, it reverts back to, it reverts back to the account holder's estate. So that's what happens in the simple example where there's one POD beneficiary, the funds go back to the estate of the account holder. In cases where there's more than one POD beneficiary, again, the POD beneficiary who died, their estate does not get anything, but the remaining POD beneficiary or beneficiaries get paid out equally, unless it's otherwise specified in the POD description, the funds. So that's, I would say, perhaps a less common. The even lesser common scenario is one which happens very rarely, but it does happen. And that is an instance where the account holder dies, and then the POD beneficiary dies. But for whatever reason, the credit union has yet to distribute the funds to the now deceased POD beneficiary. And in those cases, because the POD beneficiary survived the account holder, his estate or her estate does in fact get paid. So it's the timing there, and it's rare, but you do want to watch out for that, because if you pay it out wrong, you're going to have liability for the amount that you paid out. So that's something, fortunately, that comes up very infrequently, but it's important to take note of.
All right. How long should the credit union wait before sending delinquent accounts to Weltman to collect?
Okay, well, as a general matter, the longer you wait, the harder it is to recover. That's kind of the general rule. Typically, I would say, if you're waiting for whatever reason, 180 days, which I'm going to tell you right now is too long, during that time, the member's delinquent, they're saving up to pay a bankruptcy attorney. Other creditors are getting ahead of you and getting in line first, because you're invariably not the only person they're delinquent to. And so I would say anywhere between 60 and 120 days, you should be sending the accounts over, because after that time frame, again, for the reasons that I mentioned, the probability of collecting decreases exponentially.
Matt, do these files need to be charged off before they come to us?
Typically, we'd recommend it, but it's not required. Charge-off is not a legal function. It's an accounting one. And so that's also why, and this isn't the question, but keep in mind something else. When you do have accounts, and typically they are charged off, we still accrue interest, because courts will allow it. Courts award interest, and whatever the court awards is what stands. And so I guess to your benefit, if the court's awarding interest while your account's charged off and not accruing it, at the end you should have some, hopefully we collect the whole amount, and there's be some surplus to offset your fees or whatever. So.
Okay. Next question. Since Ohio is an at-will employment state, do we have to worry about terminating an employee? What liability could we...
Yeah, there could be some liability, even though Ohio, and most states, by the way, are also at will. So to clarify, Ohio and most states or many states, are at will, meaning you can fire anyone at any time for any reason. The big exception to that is it has to be a lawful reason. You can't discriminate, right? Of course, we know that, right? So that's the big thing to consider. And I'm confident that, and hopeful, that all of the credit unions on the call today would never discriminate against any employees in any manner. But you have to be mindful that when an employee is up for termination, they're going to allege whatever they can under the circumstances, kind of as a claim. And so we have to be mindful of people's protected classes, and if they fall within them, you almost have to expect they're going to assert them or set it up as though they might. So religion, race, gender, most jurisdictions, sexual orientation, that type of protected class. There's more fall within a class, and you can't terminate people based on those protected classes. And medical disability, you need to really be mindful of that too. What I find in cases where employees realize they're up for termination, they'll run to the doctor and come up with some medical problem. So you've got to be mindful of these things too. So even in cases where credit unions are on solid ground to terminate, you got to have in the back of your head that this could come up. And in those cases, you want to make sure you do certain things. As a general matter, and always, you want to have a handbook. You want to have a disciplinary policy which outlines what that is. And in cases where you want to have annual reviews, document any shortcomings and any follow-up that needs to happen as a result of those shortcomings. And in addition, where there are performance problems along the way, you want to follow that disciplinary policy, do the write-ups, etc., do them consistently with everybody at the credit union in terms of staff, because all too often in credit unions and frankly other employers, they don't have the documentation. For whatever reason, it was different management at the time. It's just not comfortable to be upfront with people in their shortcomings, and so they just kind of let it slide. And the problem with that is if you come to the time to terminate and we say, sorry, you really just aren't cutting it here, the employee is going to come back and say, well, I was here for 20 years or whatever the time frame is, and if there were shortcomings, you have a policy that says I'd be written up, and you didn't do that. And the lack of the write-ups and the lack of evidence that the credit union is going to have kind of works against it, because, keep in mind, jurors are employees, right? And so they're going to look at that in all likelihood and say, yeah, they're discriminated against. They don't really have anything. So that's why it's important to document the file, have the policies in place, and follow through with them on a consistent basis. And at the end of the day, that's just the reality. People don't have the documents. Most cases they do, sometimes they don't, for whatever reason. So, from a practical standpoint, sometimes it's hard for clients to stomach this, but in a case where you just have to get rid of the employee and there are factors that could lead to liability, sometimes it makes sense to just provide a severance agreement which would pay them a certain amount of severance and they go away quietly. Now, if you're going to do that, you need to make sure that you consult an attorney to draft an airtight severance agreement, because there's very specific language that has to be in there and timeframes that have to be adhered to. And if you don't adhere to them, you're basically giving them free money and they can still sue you. So, but with the right agreement, you have insulation from further claims. And frankly, you're avoiding disruption to the credit union, because if you get into litigation, not only is it timely and expensive, it's going to take certain staff away from what they otherwise need to be doing. There could be depositions, bringing other credit union staff in, very disruptive to the operation. So there is a value to paying severance.
All right, Matt, we've got a couple questions back to the repo. If auto has been totaled and there is a deficiency balance, how should we proceed? Do we let member continue make payments where there is no collateral?
Okay. If the auto is totaled, do not pick it up, ever. Okay? Because then there's no deficiency, there's just no collateral. So then your option is two things. One, hopefully there's some insurance to pay, and any balance the member is responsible for. If there's no insurance for whatever reason, then you effectively have an unsecured loan. You can call that loan and say, because there's no collateral now and you didn't have adequate insurance, you're going to owe the entire balance on the loan now, or you can continue to let them make payments. But what you do not want to do is pick up some trashed vehicle because now you have to sell it at a quote-unquote commercially reasonable auction, or you will void your ability to collect the deficiency.
Okay. Here's another question. Will WWR get a replevin on a turned-over file where we know where the collateral is but have not been able to recover it because it is in a secured community?
Yes. Yes, we can do that. I mean, that's no problem at all. Just basically, if you have an account currently, it's likely in a contingency account mode, I would think. The difference is going to be you have to set up the account appropriately. There's going to be a fee for it. They do not do replevins on a contingent basis, so it would flip to a fee-based file, at least for the replevin piece.
Okay. If you do give the right to cure on an indirect a second time, do you lose certain rights going forward?
No, I just wouldn't do it, because once you give them the right, that you have to adhere to it, right? And there's too many. It's hard enough to make sure you're legally compliant, so why add basically additional opportunities to mess up? But no, if you give it to them, you're nice.
All right, next question. Under the CARES Act, some employees may be eligible for emergency paid sick leave, as well as emergency family medical leave. Who is eligible for this leave, and when are we required to provide it?
Okay, so under the CARES Act, which became effective April 2nd of this year and extends currently till December 31st, and plan on that getting extended. They'll just wait to the 11th hour to do it. There's two provisions that employees can benefit from. One is emergency medical and family leave under the Emergency Medical and Emergency Family and Medical Leave Expansion Act, and then there's also emergency paid sick leave. The good news is under Smla, that I call it, there's only a limited instance in which an employee can take it. But first, I want to point out who's a covered employer for purposes of this act. The definition of a covered employer is basically all employers with fewer than 500 employees. I mean, they all must comply with this. The concentration of 50 or more employees within a 75 radius, typical of standard FMLA, does not apply to Smla. Okay, so the good news, however, is the Secretary of Labor can exempt small businesses if there's fewer than 50 employees, when compliance with Smla would jeopardize the viability of the business. So you'd need to establish that if you're going to try and exempt yourself from it. So keep that in mind. But employees are eligible for relief under Smla after working for just 30 days. This also deviates from significantly regular FMLA, where they must work for 12 months and have accrued 1,250 hours in that time. So big difference there. But the leave under Smla is only for when an employee is unable to work or telework due to the need to care for a son or daughter under the age of 18, or when the child's school or daycare is closed due to the coronavirus. Comparably, the emergency paid sick leave has the similar employer coverage requirements And the difference there is all full-time and part-time employees are immediately eligible. There's no minimum time to qualify under that act. And also, people who qualify for this emergency paid sick leave can have it for broader reasons. And that includes if the employee is subject to a federal, state, or local quarantine order, the employee has been advised by a healthcare professional to self-quarantine, the employee is experiencing symptoms of coronavirus and is seeking medical diagnosis, the employee is caring for a person that is subject to a state or federal or local quarantine or isolation order, or who has been so advised by a healthcare provider to self-quarantine, the employee is caring for a son or daughter whose school is closed or daycare, and an employee is experiencing other substantially similar conditions. So very, very broad. Pretty much anyone can qualify for that. So that's, that's kind of the high level on that.
All right, Matt, I have a question on VSI insurance. How does VSI insurance work with totaled vehicles?
I mean, you apply for it. Kind of off topic. So, I mean, you would apply for it. I'd have to look into it specifically for the logistics. So whoever is asking that, I can get back to them.
Okay, our 10th question today is, can we mandate the use of vacation time during the expanded FMLA leave? Okay.
So an employee can elect to run his or her existing paid leave like vacation concurrently with the 10 days of unpaid leave, but the employer cannot require it. Frankly, unless they've already used the 10 days that they get under the sick leave provision, an employee is likely going to use the emergency sick leave for 10 days first, unless, of course, they've already used it. If not, if they have used it at an earlier time and then are seeking EFMLA leave, the employee can take their accrued time, but they're not required to. After the 10-day leave period expires, the employee will be paid 2/3 of his or her rate of pay multiplied by the number of hours the employee would normally work. The employer can require the balance of the 2/3 time be filled in using PTO or vacation. Now, if the credit union currently has an FMLA policy, the application of that time should be consistent as to how this credit union applies time for EFMLA as well. For example, this might only be for accrued unused time that would be applied, after which that remaining third would be unpaid.
Okay. We did get a handful of questions that came in with the registration, and one of those questions is, what rights do you have to collect on the debt of a deceased individual?
Okay, so this is, again, state specific, but in most states, if not all, you do have the right to collect from deceased members. You'd have to file a claim through the estate in order to do so, being mindful of timing. So, in Ohio, for example, you have 6 months from the date of death to file a claim. And outside that, then you're barred. Now, another point to keep in mind is if you have a lien interest in property, a collateral, you don't necessarily have to file a claim. You can just exercise that lien right. So if you wanted to foreclose on property, you would not have to file an estate claim.
Okay, we did get a question from the audience. What do you recommend we do with a member that had a forbearance under the CARES Act, but is still not working and the forbearance is expired, and they are still unable to pay?
I mean, that's a judgment call. One thing I will say is right now, it's kind of working with your member and also putting the credit union's interests first. You could foreclose if it's not subject to the moratorium. If it is, then you're going to have to kind of continue to work with the member. I guess that's first and foremost. But you can proceed with the foreclosure. You can move it up to judgment in that case if you're able, and just sit on the judgment. The concern is this moratorium is going to come to an end sooner or later. Even larger financial institutions that are not subject to the moratorium are basically imposing a self-moratorium. But again, that's going to end. And at some point, the floodgates are going to open. Courts are going to be overwhelmed with these. And the credit union who didn't file and could have is kind of in the back of the line. Whereas if you move forward with the foreclosure, if you're able, even if you don't ultimately execute on it, you're ahead of the game. You could also encourage them to work out a deed in lieu of foreclosure, where we find a buyer, or even a short sale that's amicable. Those would be the kinds of things you want to consider. The market's hot right now. I think most people know that. So, it's not a terrible thing to be in a position where, as a financial institution, you're selling property. That's going to change at some point. So while you want to help your members, if they're indefinitely not going to be able to pay, it's not a short-term thing. In other words, you might want to encourage them to take advantage of something like a deed in lieu.
All right, Matt, what are the credit union's rights if the probate estate is not opened within 6 months?
Well, that's the statute of limitations, so to speak, and the SOL, and SOL comes to mind. You can execute on the lien if you have it. If you have a credit card or you have some unsecured loan, you're out of luck.
Okay. Due to COVID-19, what cautions should we take before repossession or collections? Have collection processes changed, or is it business as usual?
Overall, I would say it's business as usual. Certainly in Ohio, obviously with there are some real estate limits on federal-backed mortgages, with moratoriums on foreclosure and eviction. But beyond that, business as usual. That could be subject to change at any time, right? We're already seeing concern that as we move into the fall, there's going to be an uptick in coronavirus cases. And that changes the landscape, and states very quickly may react to that and put limits in place that currently aren't in place. For example, you recall back in March, only mandatory businesses were allowed to perform, and essential businesses were allowed, and repo companies weren't considered essential, so that kind of stopped the repos. So you just kind of get to keep your ear to the ground and anticipate. But right now, I would move forward as business as usual. Okay.
We have a 1099-C question. Is it required to issue I know. Is it required to issue a 1099-C if a settlement is entered into between the debtor and the credit union? An example would be original charge-off $5,000, settled for $3,500, difference $1,500.
Yes, it is required. Anything which forgives more than $600 of the debt requires the filing of a 1099-C.
Okay. Another question, can deeds transfer without lien holder being notified?
Yeah, it's called a quitclaim deed. It has no bearing on you whatsoever. So, you potentially could consider it a default event under your loan, but it doesn't void your lien.
All right, here's an interesting one. Are we able to sell repossessions to a resale company like Carvana?
No. Vehicles that are repossessed must be sold in what's called a commercially reasonable sale. It must be held out to the public. There must be a bidding opportunity. There must be advertising, all of that. And so Carvana, just selling directly to them voids that. Now, that's the legal answer. I'll give you the practical one, because life is about risk and weighing risk. And Sometimes if you want to roll the dice, you want to roll the dice. If you do a sale like that, you're barring your ability to collect a deficiency. Maybe, based on whatever the factors are, we're not collecting the deficiency, so I just want to get as much as I can for the car. Then go for it. The only real risk in that case is, could the member or the estate of the member or whatever come back and say, the loan value was $20,000, that vehicle was worth $40,000, there should have been a $20,000 surplus, you only sold it for $18,000, you owe us $20,000. I mean, they'd have to prove that, right? They'd have to show evidence to that effect. So if you have collateral that's disparate like that, I wouldn't do it. But in that case, if the collateral's, if you're that well secured with the collateral, you shouldn't have any problem sending it to a public sale, because even a wholesale amount would get you where you need to be.
Okay. Well, we've reached our hour. If there's any questions we did not get to, or if you have further questions, please email either Matt or myself. I want to thank everyone for your time today. I hope this presentation was informative. There will be a recording of this presentation along with a brief survey sent to you later on. Be sure to visit our website at weltman.com to view upcoming webinars. Thank you, everyone, and thanks for attending.
Thank you.